welcome to the debate. By April of this year, 2026, nearly 500 licensed lawyers were formally sanctioned by judicial committees. And we aren't talking about, minor filing errors here.
No, definitely not.
Right. These were attorneys standing before federal judges, submitting briefs that cited case law that fundamentally did not exist. The artificial intelligence they trusted, it didn't just make a mistake, it invented, perfectly formatted, grammatically flawless citations for phantom court cases.
Yeah. And that's the terrifying reality of the legal profession right now. I mean, it is a crisis of trust. A machine can write a beautiful sentence, but if that sentence contains a fabricated legal precedent, it is basically a ticking time bomb for any lawyer who files it.
Which brings us to the core of what we're debating today. Today is August 25th, 2026, and Google Cloud has officially launched Gemini Enterprise for Legal.
Right.
So this is an agentic artificial intelligence platform engineered specifically for law firms and corporate legal departments. And our focus today is whether this specific technology represents a structurally sound, transformative evolution that finally solves the legal industry's core workflow challenges. Or,
whether its highly publicized governance frameworks are really just a polished veneer over that fundamental unsolved danger of AI hallucinations.
Exactly. Are we looking at a genuine architectural breakthrough or just a very expensive Band-Aid over the same underlying quicksand?
Yeah, the quicksand is a good way to put it.
Well, I will be making the case that we are looking at a genuine breakthrough. Gemini Enterprise for Legal marks a crucial paradigm shift because it fundamentally changes how the AI operates. We are shifting away from generic conversational chatbots to highly governed, task-specific, they call them skills, with verifiable grounding.
Right, the skills framework.
Yeah. It is backed by robust governance, integrating directly into existing legal ecosystems like iManage, NetDocuments, and DocuSign. By grounding its data in verifiable primary sources like courtlistener.com, it creates a centralized control plane for IT and risk teams. And frankly, the adoption of this platform by notoriously risk-averse Magic Circle and top-tier global law firms like Cleary Gottlieb, Freshfields, Weil, and Williams Connolly, that serves as definitive proof that the platform actually meets the stringent demands of top-tier legal practice.
Well, and I will argue that the empirical evidence tells a completely different story. The underlying risks of AI hallucinations in specialized legal tools remain unacceptably high. And that creates a productivity paradox that negates the tool's intended value.
A paradox. Okay.
Right, because the fundamental structural flaw of generative AI simply hasn't been solved by this verticalization strategy. The data is clear. I mean, the 2025 peer-reviewed Stanford RegLab study in the Journal of Empirical Legal Studies, it demonstrated that even specialized legal AI tools utilizing retrieval augmented generation, or RAG, they still hallucinated between 17% and 33% of the time.
Yes, I'm familiar with the study.
Right, and the real-world consequences are severe. We have 1,313 documented judicial proceedings involving AI hallucinations by April of this year. Because the error rate is still so significant, the required human verification completely erodes the promised productivity gains. So what is being sold as operational efficiency is actually, well, it's a massive professional liability.
Okay, let's start with reality of who is actually deploying this in the real world right now, because I think the market's response is incredibly telling.
Sure.
The participation of firms like Cleary Gottlieb, who are absolute heavyweights in M&A, and Williams Connolly, known for high-profile litigation, this isn't something we can just brush past. These are not Silicon Valley startups adhering to a move fast and break things philosophy.
No, they certainly aren't. I mean, they're the opposite of that.
Exactly. These firms have deeply conservative risk cultures. Their entire business model is predicated on mitigating risk, finding flaws, and protecting client confidentiality. The fact that they are utilizing Gemini Enterprise for Legal as launch clients, integrating it seamlessly into their daily routines to deliver higher quality work, it signals that the technology has passed the most rigorous stress tests imaginable. They wouldn't touch it if the structural integrity wasn't there.
See, I come at it from a different way. Early adoption by billionaires doesn't mean the bridge is structurally sound for everyone else.
Okay.
What we are seeing with Cleary Gottlieb and Freshfields isn't necessarily proof that the AI is inherently safe. It is proof that these megafirms have the immense capital required to build an enormous, highly customized safety net around a fundamentally unstable core technology.
I see why you think that, but let me give you a different perspective. You're framing their adoption as if they are just throwing endless money at our problem to hide the flaws. But look at the mechanics of the deployment.
Okay.
The presence of massive consultancies like Accenture, Deloitte, and KPMG managing the deployment proves this isn't a careless rollout. It is a meticulously governed integration.
Right, but
They're establishing a centralized control plane. They're building audit trails natively into the architecture of the platform, ensuring that every piece of data the AI touches is tracked, permissioned, and verified.
you're making my point for me.
How so?
If a piece of software requires Accenture, Deloitte, KPMG, and a whole host of specialized legal tech consultants like Factor Law and Tribe AI just to safely configure its API limits and data silos, you are looking at a widening equity gap in the legal profession.
Well,
Only firms with massive technology budgets can afford the accompanying consultancy and deployment costs to mitigate the risks.
it is enterprise software, though. I mean, enterprise software always requires integration.
But we are talking about access to justice too. What about the mid-sized firms, the independent practitioners, or the legal aid clinics who cannot afford this enterprise-tier governance?
Sure.
If the tool requires $1 million consultancy wrapper just to prevent it from inventing case law, the underlying technology is still fundamentally too dangerous for the broader legal ecosystem. You are praising the wrapper, but I am looking at the engine inside.
Okay, then let's look directly at that engine, because we have to separate the deployment model from the actual architecture of the tool. Google's approach here fundamentally bounds the AI's capabilities. We are no longer talking about the 2023 era of opening a general model, asking it, should I sue my neighbor over this property line, and crossing our fingers that it gives good advice.
Right, the Wild West days.
Yeah. Gemini for Legal is executing administrative, verifiable actions. It utilizes specific skills.
Define what you mean by skills in this context.
It means the AI isn't operating as an open-ended conversationalist. A skill is a rigidly defined protocol. We're talking about extracting standard deviation clauses from a 300-page contract, or executing data subject access requests, or preparing documents for motions to seal.
Okay.
These are tasks where the output is strictly defined, highly bounded, and immediately measurable against a specific source document. It is not generating legal theory. It is extracting and structuring existing data.
I'm sorry, but I just don't buy that. Let me tell you why. You're drawing a distinction between substantive legal judgment and administrative tasks as if the AI actually knows the difference.
Well,
It doesn't.
it knows what parameters it is operating within.
But it doesn't understand the meaning of the parameters. Generative AI fundamentally operates by predicting the next most statistically likely token.
Right.
It is essentially the world's most advanced game of autocomplete. It strings together words that mathematically belong together based on its training data. It does not understand the concept of truth. It doesn't know the law, so when you ask it to extract a clause, it is still just predicting text.
But it's doing so within a highly constrained environment.
And yet, it still fails. I mean, going back to the 2025 Stanford study, they explicitly tested specialized tools from industry leaders like LexisNexis and Thomson Reuters. Tools that were supposed to be bounded and specific, just like you're describing.
Yes, but
Those tools still failed up to a third of the time. Now, yes, general models from a few years ago failed 58% to 88% of the time. Things are getting better,
significantly better.
but the current baseline of approximately 80% accuracy for specialized tools is fundamentally incompatible with a profession that demands near 100% factual accuracy. 80% precision means 1 out of 5 citations or contract analyses could contain a hallucination. In corporate law, one hallucinated indemnification clause isn't an acceptable margin of error. It's a disaster.
You are talking about the inherent nature of next token prediction, but the way you fix that is exactly what Gemini Enterprise is doing through grounding.
Okay.
Grounding the model in primary, verifiable sources directly targets the hallucination issue you're so concerned about. You mentioned the Stanford study, which looked at early versions of retrieval augmented generation, or RAG.
Right.
Gemini for Legal advances this significantly. It explicitly ties the model to open access databases like Court Listener and specialized legal software like RelativityOne and Everlaw.
Which is still fundamentally RAG.
Yes, but highly optimized. It restricts the model to factual authority rather than relying on its parametric memory, the data baked into its neural network during its initial training. Think of it like this. An ungrounded model is like a student taking a highly technical exam from memory. They might panic and invent an answer that sounds plausible.
Sure.
Gemini for Legal is taking an open book test, but the system forces the student to literally highlight the specific passage in the textbook before they're allowed to write down the answer. When the model needs to verify a citation, it doesn't try to remember the case. It searches Court Listener, pulls the actual text, and generates its response based solely on that verified document.
The open book analogy is great, except it ignores how the AI reads the book. The mechanism of grounding the vector search and retrieval is exactly where the failure points occur in complex legal work.
Well, I'll explain what you mean by that.
So RAG works by searching a database, pulling relevant text chunks, and feeding them to the AI to summarize. The problem is twofold. Sometimes the search retrieves the wrong context because it misunderstands the nuance of the prompt, and sometimes the AI synthesizes the perfectly correct context poorly.
But if it's restricted to only pulling from the verified database, the risk of a pure fabrication drops dramatically.
Drops, yes, but it doesn't disappear. And in complex global law, it breaks down entirely. Consider the October 2025 Weil's AI Legal Research Report. It showed a massive 14-point drop in accuracy when AI tools were tasked with 50-state, multi-jurisdictional surveys.
To be fair, multi-jurisdictional surveys are notoriously difficult, even for experienced human lawyers.
True. But human lawyers know when they are confused. They stop and ask for help. And AI fails silently. Let me explain the mechanism of this failure.
Go ahead.
When you ask the AI to synthesize how a specific labor law applies across 50 different regulatory frameworks, the semantic search gets overwhelmed. Because the AI maps language mathematically in a vector space, the words exempt employee in California look mathematically identical to exempt employee in Texas.
Right, to the machine.
Exactly. The AI can't distinguish between a nuanced California exemption and a Texas statute because it mashes those vectors together. It loses the logical thread and hallucinates a blended regulatory standard that doesn't exist anywhere. For international firms like Google's launch clients, this is terrifying. You think you are grounded in factual authority, but the architecture simply cannot handle the conflicting nuances of global jurisdiction.
The multi-jurisdictional complexity is a real technical hurdle, I will grant you that. Semantic blending in edge cases is something the engineers are still refining, but we have to look at the baseline of what it accomplishes before it hits those specific edge cases.
Okay.
Even with required human oversight, automating the first draft of regulatory monitoring reports or doing the initial review of a massive data room in an M&A deal represents an undeniable leap in productivity.
But where is the productivity if you have to double-check every single line?
The mechanical advantage is staggering. If an AI can review a 500-page lease agreement and highlight 90% of the non-standard clauses in 3 seconds, the human attorney only has to verify those highlights and catch the remaining 10%. They aren't reading 500 pages from scratch. They are auditing a highly accurate first pass.
That's a compelling argument, but have you considered the sheer cognitive load required to audit a machine's output? The psychology of human-computer interaction warns us heavily about automation bias.
The tendency to trust the machine.
Exactly. We naturally trust a machine's output, especially when it sounds highly confident, perfectly formatted, and authoritative, which Gemini absolutely does.
Right, it writes very well.
It writes beautifully. If every single AI-generated claim must be rigorously vetted to avoid professional ruin, where is the efficiency? And we aren't talking about theoretical ruin either. Let's look at the database maintained by the Hey QQ Legal AI Tracking Project. By April 2026, 496 licensed lawyers were formally sanctioned for AI hallucinations.
Yeah, those numbers were sobering.
And the penalties are escalating. Fines escalated 11-fold in just 18 months.
peaking at $55,597 in 2025 for a single incident. That isn't just a fine, that is public professional humiliation. The time saved on the initial draft is entirely consumed by the agonizing verification process required to ensure you aren't the next lawyer facing the disciplinary committee. It is often significantly harder to find a well-disguised lie than to write the truth from scratch.
I'm not convinced by that line of reasoning because human verification of someone else's work has always been a fundamental core part of legal practice. This isn't a new burden.
It feels new to the people doing it.
Well, partners review the work of senior associates, right? Senior associates review the work of junior associates. Junior associates review the work of paralegals. The cognitive load of auditing a first draft isn't a new phenomenon created by AI. It is the defining characteristic of a mid-level lawyer's day.
Auditing a human is completely different than auditing a large language model.
But the workflow adapts. The AI simply changes the nature of the first draft. Yes, it requires a different kind of vigilance, but the assertion that finding an error in an AI draft takes longer than manually reading 10,000 pages of discovery is empirically false.
I don't know if I agree with that.
Well, the legal team learns to prompt the AI to show its work, to provide the exact paragraph and page number from iManage or Everlaw where it derived its conclusion. That is the essence of the skills framework Google is deploying. You click the citation, it opens the exact source document.
Okay, but the qualitative difference in the type of error is what makes the verification process so insidious. Think about it. When a junior associate is confronted with a gap in their knowledge, they will come to your office and say, I searched Westlaw for 3 hours and I just couldn't find a case that supports our position.
True.
An AI, driven by its underlying directive to fulfill the prompt and predict the next token, will simply invent one.
Which is why we use grounding to restrict it.
Even with grounding, when the retrieval fails, the AI fills the gap. When a human makes a mistake, it usually follows a logical, understandable flaw in reasoning. You can trace their thought process and correct it.
Yeah, you can sort of see where they went wrong.
Right. But when an AI hallucinates, it generates a perfectly formatted, grammatically flawless citation to a phantom volume of the Federal Reporter that never existed, complete with a fabricated quote that perfectly supports your argument.
It is very convincing, I'll give you that.
The cognitive dissonance of auditing a system that is simultaneously hyper-competent in syntax and completely detached from reality creates massive operational friction. The human verification bottleneck isn't just about time. It's about the exhaustion of constant high-stakes skepticism.
And that skepticism is exactly why the deployment of this technology at the enterprise level is being managed so carefully through platforms like Gemini Enterprise. The IT and risk teams are given a centralized control plane specifically to mandate that the AI cannot generate responses outside of the closed universe of the firm's own data or verified databases.
Right.
By restricting the model's freedom at the administrative level, you drastically reduce the space in which it can hallucinate. You're right that generative models fundamentally want to please the user, but when you enforce strict retrieval parameters, you essentially put heavy, unyielding guardrails on that behavior.
Guardrails are helpful, certainly, but let's remember the Stanford RAG Lab study tested RAG-enabled tools. Those tools already had guardrails. They were already supposedly restricted to closed legal databases, and they still returned errors in up to a third of their responses.
But the technology improves.
The technology improves, yes, but the leap from 80% accuracy to the 99.9% accuracy required in legal practice is not a linear progression. It is an exponential wall. Closing the gap on those final 20 percentage points is phenomenally harder than getting from 50% to 80%.
Because you're dealing with edge cases.
Because you are fighting the foundational architecture of the neural network itself. And while we wait for the technology to scale that wall, the professional liability falls squarely on the shoulders of the practitioners.
It always has, and it always should. Technology is a tool, not a scapegoat. The fact that the liability remains with the human lawyer is a feature of the legal system. It's not a bug in the software.
I suppose that's one way to look at it.
What Gemini Enterprise for Legal represents is the responsible maturation of AI for high-level legal practice. By moving away from general chat interfaces and building a highly governed, skill-specific architecture integrated deeply with primary legal databases, it gives law firms a powerful engine for processing the overwhelming volume of data inherent in modern law. The structural integrity is built through targeted integrations and rigorous deployment protocols.
And yet, the documented 17% to 33% hallucination rates in specialized tools, combined with the drastic multi-jurisdictional drop-offs we've seen when the semantic search gets overwhelmed, mean the technology still presents a dangerous professional liability.
Right.
It is currently disguised as an efficiency tool. Until the underlying architecture of large language models can natively understand factual truth rather than just mimicking authoritative legal phrasing, the quicksand remains. Relying on heavy consultancy wrappers and the massive technology budgets of magic circle firms to plaster over these fundamental flaws doesn't solve the problem for the legal profession as a whole.
Well, it seems we are arriving at a clear point of convergence. Despite our differing views on the technology's current structural soundness, we both agree on one undeniable reality highlighted by the data.
Which is?
Strict human supervision is absolutely mandatory before any AI-generated document reaches a client or a courtroom.
Oh, on that we are in total agreement. The human in the loop is non-negotiable. The moment a lawyer trusts the machine more than their own rigorous verification process, they are risking their license.
As we reflect on the broader implications of what Google is doing here, it's vital to note that this verticalized AI approach isn't stopping with the legal industry. Google plans to expand this exact industry-specific architecture to finance and healthcare next.
Wow, okay.
Yeah, the debates we are having today about legal citations and contract clauses will soon be debates about financial compliance audits and patient diagnostic reviews.
Which makes the need for independent, empirical research all the more urgent. The true efficacy of Gemini for legal or whatever comes next in finance and healthcare will only be proven by future independent studies like those from Stanford and the Weil's AI reports. We cannot rely on corporate press releases or early adoption announcements from firms with bottomless IT budgets. We have to keep meticulously measuring the error rates in the real world.
And that empirical measurement will tell us, ultimately, whether we are building on a solid, verifiable foundation or whether we are just pretending the quicksand isn't there. Thank you for joining us in this discourse. The evidence is on the table, the perspectives have been laid out, and the final judgment, as always, is yours to make.